Salam and greetings. Today, I will present two cases review related to subsidiary legislation and discretionary power. In this presentation, I will try my best to identify issues, cases, facts, basis of judgment, or personal comments if necessary. All right, I'll start. For the first case, I refer to the Oi Kentong and another against Public Prosecutor 2006. The fact of the case was that the applicants were lovers and had been alleged by the BKL on 2 August 2003 with disorderly manner to it hugging and kissing. The applicant's behavior amounted an offense under the Section 8, Clause 1 of the Parks Federal Territories by Law 1981 at the time. Both of applicants received summons from the BKK and supposed to pay a fine. However, the applicants did not pay for a long time and changed their mind by challenge the summons to the High Court after receiving consent from the public prosecutor. There were two important issues arose in this case, namely regarding subsidiary legislation by High Court is ultra-virus, and secondly is statutory interpretation of fundamental liberties in federal constitution. The first issue is whether the impugned by law is ultra-virus, Section 102 of the Local Government Act 1976. However, the federal court held the impugned by law is intra-virus, Section 102 of the Act. Meanwhile, the second issue is whether the impugned by law or its effect infringe the right enshrined in Article 5 and 8 of the Federal Constitution. In the decision of judgment, the Federal Court held that the impugned by law does not infringe any of the rights as enshrined in Article 5 or 8 of the Constitution. The ground of the judgment by the Federal Court on the first issue is that Section 102 should be seen as two limbs, which is general in nature, while the other limb is on specific area. For example, the connectivity test between the object of the impugned by law and Section 102 seemingly like the connection contemplated is real and proximate, not far-fetched or problematical, as can be seen in Public Prosecutor against Pung Chen Chun. In other words, the general nature of the section is broad enough to cover such matter as dealt with in the impugned by law, with kissing and hugging alleged. According to Federal Court, the matter of indecent or disorderly manner depends on the prevailing circumstances, place, and or period of time. As for the kissing and hugging, the Federal Court gives the same example that although singing is allowed, but singing in the park at midnight definitely disrupts the sleep of others. Then, it amounted to disorderly manner as in the phrase as unnecessary or desirable for the maintenance of the health, safety, and well-being of the inhabitants or for the good order and government of the local authority area of Section 102. Even though the Federal Court did not yet decide that kissing and hugging are immoral manner, however, in the scope of DBKK by law, it's still an offense according to general in nature of Section 102. Whilst DBKK had the right to enforce of the bylaw was met. Then the issue arose about ultra-virus is void but intra-virus since the bylaw fall within the ambit of the parent act. Meanwhile, in the second issue, as determined by the court in its judgment that the impugned by law does not infringe any of the rights as enshrined in Article 5 or 8 of the Federal Constitution. The decision was made with scrutinized judgments. One of the main points is it has been stipulated that Section 8 Clause 1 of the Parks, Federal Territories Bylaw 1981 is intra-virus Section 102 as Parent Act and court find the enacted bylaw to be valid. Therefore, there is no question of any infringement of the rights enshrined therein in the applicants. Secondly, Article 5 and Article 8 of the Federal Constitution do not apply to the situation of applicants as they have never been detained or arrested. Thus, no issue arises that deprivation of fundamentals of liberties has occurred, especially in the case of deprived of life put forward by counsel. Lastly, as the keeper of its public parks, DBKL is entitled to lay down the rules to regulate their uses, and more so in this case where the Act provides such power to DBKL. In response, if a person does not wish to be subject to such regulations, as for instance, not to behave in disorderly manner, he or she is not obliged to enter any of the public parks to do what he or she wants to do. It will therefore be quite illogical to insist entry into the public park and then demanding unqualified personal liberty. The interests of other users who are equally entitled to invoke Article 5, Clause 1 must also be respected. As a conclusion to this review case, subsidiary legislation must not exceed the power of existing legislation to avoid the occurrence of ultra-virus on the Parents Act. The second article, content of discretionary power topic. The case cited is Peguam Negara Malaysia against Chin Chikau as Secretary of Persatuan Kebajikan, dan Amaliam Hud Thong Cho Seng Tuan and another appeal 2019. The facts in this article began when Chan Leong Ken, as a testator, bequeathing for plots of land and 15,000 for the construction of the pagoda, while 5,000 to be invested so that the income from it will be used to maintain the pagoda. On 6 May 1941, he had executed a will and kodai sale along with a trust deed. However, since the death of the testator, the initial trustees failed to execute the trust while the money was fully used up. Therefore, on 20 August 1982, the High Court had dropped an order declaring the land as a public charitable trust, applying the principle of the Cyprus Doctrine. After 35 years have passed, there is still no effort by the trustees to execute the will of the testator through Cyprus, and the land are left vacant. The association seek funding from third parties to build the pagoda. However, to obtain funding, the association must meet the prerequisite of being appointed as a trustee to provide a legal position to execute the agreement on behalf of the trust. Therefore, through letters dated 20th of November 2014 and 6 July 2015, the association applied to the Attorney General of Malaysia for permission under Section 9 of the Government Proceedings Act 1956 to apply to the High Court to be made a trustee in addition to or replacing the current trustee. However, in a reply letter dated 17 February 2016, the Attorney General refused to give his consent on the grounds that the permission had been previously granted to the current trustee on 15 March 2014. Aggrieved with the Attorney General's decision, the association sought leave to the court to initial judicial review for obtaining said subsidiary and mandamus orders. In this case, the federal court is required to decide whether the prerogative of the Attorney General is incompatible with the judicial process. This case consists of two appeals, namely Civil Appeal 58 as first appeal and Civil Appeal 57 as second appeal. Both focus on the same question, which revolves around Section 9 of the Government Proceedings Act 1956. According to Section 9, Clause 1 of the Act, provides that the Attorney General has the power to give written permission to a person having an interest in a trust for public, religious, social, or welfare purposes to initiate a suit on behalf of the government or the public for the purpose inter alia of asserting any interest in trust property. In this first appeal, the question is whether the Attorney General's written consent under Section 9 in relation to a civil case is improper or cannot be reviewed. Meanwhile, in the second appeal, the question is whether the Attorney General's written consent under Section 9 in relation to a civil case is justiciable or reviewable. In delivering of judgment, the federal court held that the Attorney General's power to give consent or otherwise under Section 9, Clause 1 of the Government Proceeding Act 1956 was not absolute and was subject to legal limits. Unfettered discretion was contradictory to the rule of law. Hence, the Court of Appeal in Appeal number 58 did not err in holding that the Attorney General's power to give or refuse consent under Section 9, Clause 1 of the Government Proceedings Act was amenable to judicial review. It was settled law that the Attorney General was a public officer under the Federal Constitution, and Article 145 give ample power to the Attorney General to represent the government or person performing any functions under the Constitution. The Attorney General's discretionary power to give or refuse consent pursuant to Section 9, Clause 1 of the Government Proceeding Act was derived from statute law, and any restrictions and conditions applicable to statutory power could not be ignored. So, the federal court dismissed the appeal of number 58. While in appeal number 59, the judge unanimously allowed this appeal on the ground that the court could not agree with the contention that the orthodox common law immunity from judicial review of the Attorney General's prerogative powers as laid down in Gorit against Union of Post Office Workers 1978 was still good law in view of the House of Lords division in Council of Civil Service Unions against Minister for the Civil Service. This later landmark decision moved the courts from a position of deciding whether prerogative power existed to deciding if they were being carried out lawfully. The judgment in Gorit's case was a reflection of past judicial refusal to inquire into the way in which a prerogative power had been exercised. With the progressive development of judicial review, the court been more willing to review the exercise of discretionary power, whether derived from statute or a prerogative power. The present position was that the Attorney General was no longer regarded as the sole guardian of what was public interest, which was a central principle in the division in Gorit's case. In this appeal number 59, Learned Senior Federal Counsel submitted that the Court of Appeal had erred in failing to appreciate and apply the legal principles laid down by the House of Lords in the case of Gorit against Union of Post Office Workers, in holding that the decision of the Attorney General under Section 9, Clause 1 of Act 359 is amenable to judicial review. Learned senior federal counsel referred to the oft-quoted dictum by Viscount Dilhorn of the Goret case. The Attorney General has many powers and duties. He may stop any prosecution on indictment by entering a null prosecution. He merely has to sign a piece of paper saying that he does not wish the prosecution to continue. He need to give any reasons. He can direct the institution of a prosecution and direct the director of public prosecutions to check over the conduct of any criminal proceedings, and he may tell him to offer no evidence. In the exercise of these powers, he is not subject to direction by his ministerial colleague or to control and supervision by the courts. In my opinion, the view that refusal of consent to a related action is an exception to the general rule and is subject to review by the courts must be rejected. It is because I think it is undesirable that any judicial observation suggesting that the exercise by the Attorney General of this function and duties is subject to control, supervision, and review by the courts should be left unanswered, that I have ventured to make these observations. And now, as a conclusion and commentary for this case, the Federal Court ruled that the Attorney General obtained his power to grant leave or otherwise from the statute, namely Section 9, Clause 1 of the Government Proceedings Act. Thus, no constitutional objection exists to the jurisdiction of the court used to review decisions made by the Attorney General pursuant to the statute. The Attorney General's discretion under Section 9, Clause 1 differs from the Attorney General's discretion, which is not bound by the prosecution of criminal offenses under the Federal Constitution. Such unlimited discretion should not be allowed in civil cases, especially when it involves the public, as this can lead to abuse. Therefore, the power of the Attorney General to grant leave or otherwise under Section 9, Clause 1 is not absolute and is subject to legal limits. That's all of my presentation. Then it's bring me to the end of my presentation. Thank you very much.